Hi everyone. So the unit that we'll be doing today is business law, and the learning outcome, today's learning outcome is to illustrate the potential impact of law on businesses. We've looked at learning outcome 1 previously, so I'm just going to give you a summary of what we did in learning outcome 1 first before we go on to learning outcome 2. So in learning outcome 1, we looked at explaining the nature of the legal system. We looked at what the legal system in the UK is, where it has a set of rules, procedures that govern the administration and how laws are enforced. We looked at, in learning outcome 1, we looked at the purpose of law, why there's a need to have laws in place, and why there's a need to have criminal law and civil law in place in regards to that. We also looked at the evolution of law, so how it was established thousands of years ago, how the laws were established and how they came about since Anglo-Saxon times up till today. We then went on to look at the different sources of law. So you have primary and secondary sources, primary sources being things like legislation, secondary sources, primary sources, legislation, acts of parliament, statutes, statutory instruments, orders in council, and primary source being case law as well. We then went on to look at secondary sources of law, such as textbooks, commentaries, opinions of legal experts, decisions of the courts. And we also went to look at the divisions of the legal system, which we went through each one. So we have the Supreme Court, which is the highest court, which was formerly the House of Lords, but now is the Supreme Court. Then we had the Committee of Privy Council and Judicial Committee of Privy Council, the Court of Appeal, the High Court, Crown Court and County Courts, Magistrates and Tribunal Services. So we went through the court structure, what each court dealt with, and within the High Court, they have 3 divisions: Queen's Bench Division, Family Division and Chancery Division. We went through what kind of cases were held in each court and what kind of cases were dealt with in magistrates in Crown Court. We then went on to look at the difference between civil and criminal law with reference to examples. So examples of civil cases could be things like family disputes involving divorce, children issues, maybe childcare arrangements, personal injury, road traffic accidents, breach of contract, so there's a contract, a promise, employment law, any sort of discrimination. We then went on to look at criminal law, which is bought by the CPS, which is literally the name for the Crown, so the Crown Prosecution Service. And examples of criminal cases: criminal damage, sexual assault, murder, fraud, money laundering, drug dealing. We then went on to look at the justice system in the UK and how it works, and how we have 3 branches of state as the executive, the legislature and the judiciary, who deal with the elements of the justice in the UK. We looked at the role of the government in making laws, making the laws, how an Act of Parliament goes through the various stages to become, how a bill goes through various stages to be approved by the both houses, House of Lords and House of Commons, and then becomes an Act of Parliament. We then went on to the organisation structure of the judiciary, and there was a video there for you to look at in your own time by Lady Hale on the role of the judiciary. So this was like an overview of the introductory of the English legal system, how it works, how the justice system works, what the divisions are of the legal system, so the court structure, how the judiciary is organised with reference to judges, lay magistrates, lords, and also the purpose of how sources came about, legislation, treaties, directives, why there was a need. And you need to know the history of the evolution of law and how it came about thousands of years ago, when kings ruled the country, and then it went to the development of certain certain establishments, and also certain acts like the Judicature Act, common law, the cases were dealt with, and then how cases came about and how it all developed slowly up till the 21st century now, and how it's changed dramatically. There's still changes going on now as well. So that was learning outcome 1. Now we're moving on to learning outcome 2, which is looking at the potential impact of law on businesses. And it will have a big impact on businesses because, you know, it's the looks at the relationship between, you know, society and businesses. You know, it affects the world as a whole. Learning outcome 2, the indicative content. So the impact of law, contract law, for example, the formation of contract, the elements and the terms of a contract, competition law, data protection, the tort of negligence, so consumer protection, health and safety, product liability, duties of employer and employee, the employment contract, employees' obligations, managing cases of dismissal, redundancy, discrimination, and health and safety. So key terminology, the impact of law. Law protects our general safety and ensures our rights as citizens. And we have laws to help us provide, you know, general safety. So, you know, law relates to society as a framework of rules and regulations that govern the human behavior, you know, so it reflects on our norms and our customs. Impact of law on businesses. So the government use legislation to regulate business behavior and prevent any sort of discrepancies. And if a business is found in breach of any sort of health and safety laws, it could get fines and legal actions. So here is a video that you can watch in your own time that looks at explaining how legislation impacts business in terms of cost involved and positive and negative consequences of not following the legislation. So, you know, it's really important that, you know, you follow the legislation because you have to meet the requirements of the legislation, and, you know, you need to make sure that you are following the laws, because the business will not run without the laws in place. Businesses of all sizes and all sectors are subject to a wide range of legislation, which can have a significant impact on their operation and profitability. So, you know, you need to look at that. You know, one of the main ways in which legislation affects businesses is through the cost of compliance. All businesses must comply with a wide range of laws and regulations, from things like health and safety, you know, to tax laws and data protection, you know, regulations. These laws are complex and time-consuming to navigate, and businesses must often invest in legal advice, training, and equipment to ensure they're compliant. So the first one, the health and safety, is a really important one, which is one that's, you know, that needs to be adhered to all the time. You know, people need to adhere to the basic health and safety impact of a business, you know, how it's run. So when working environment is dangerous, a business will be accountable for the safety of their employees. This means to need to ensure minimum standard of, you know, minimum standard of safety is adhered to. The next one is employment legislation. Governments also pass legislation that protects people that work there, which we'll go in more detail later on. Environmental legislation on businesses to ensure there's certain standards to provide tax and subsidies. Governments need to ensure that they meet the requirements of, you know, the issues around, you know, taxes and finance if they work in a manner that's undesirable. Businesses, an example I'll give you, businesses in the UK are required, and we'll go through this a little bit more, required. An example is GDPR, which came into force in 2018, which the legislation requires business to protect the personal data, you know, of any person, but personal data of their customers and employees, because that can be really costly for any sort of business. But another key way in which legislation affects businesses is through the consequences of not meeting the legal obligations. So failing to comply with the law can be a serious consequences. So if a business is found in breach of health and safety laws, it could face fines, legal action, and even prosecution. In legislation can have a significant impact on businesses, both in terms of cost and compliance and consequences of meeting or not meeting legal obligations. Businesses must navigate a complex landscape of laws and regulation and must invest again in the training and ensuring they're fully compliant. Contract law is a body of law that applies to rights and obligations. And of contractual parties under a contract. It governs the relationship, validity, and interpretation of an agreement between two or more individuals regarding the sale of goods, the provision of services, or the exchange of interest or ownership. The formation of a contract. The formation of contract refers to the process through which parties establish a legal binding agreement governed by contract law. It typically involves an offer made by one party, an acceptance by the other party, and a mutual exchange of consideration. So an offer allows the other party to accept the offer, as we've mentioned, providing the basis of a formal agreement. Or the other party can refuse. Such an offer must be communicated to the other party. So elements of a contract. There are certain key elements to consider when forming a contract. These elements determine the validity and enforceability of the contract. So a contract, like we said earlier, is a legal binding agreement between two or more parties concerning all the relevant elements that create enforceable obligations between them. Offer and acceptance are the main building blocks in contract formation. An offer is a proposal by one party to another outlining the terms of the potential agreement, and acceptance occurs when the offeree clearly communicates the agreement to these offers. For example, if Alice offers to sell her car to Bob for £10,000 and Bob agrees to buy it on those terms, there's a valid offer and acceptance and a contract is formed. So as we mentioned, the elements of a contract: offer, acceptance, consideration, intention to create legal relations, authority, and capacity. Uncertainty. With these elements, a contract is not legally binding. So these elements must play an essential part of a contract. You must be aware of when a contract is made, and that it's legally binding with an offer, acceptance, consideration, intention to create legal relations, authority, and awareness. So you need to make sure that these contracts govern businesses, and much of their potential revenue is driven by signed contracts. That's why companies are investing in their contract processes to ensure that every contract is implemented with complications. So only some contracts are enforceable, even if contracts written in legal jargon. So you need to make sure that these contracts are enforceable and make sure that you've followed the elements of it. So the terms of a contract. A contract term is any provision or term that forms part of the contract. Each of these terms provides a contractual obligation which can lead to litigation if breached. So, there are contracts in place, there are terms in place that we must follow, and the element of the term is if the terms are not followed, then, there's a breach of contract. So it's really important that that you follow the terms of the contract and the formation of the contract, that the terms are in there. So the legal part of contract are known, as we mentioned, as terms. An employer should make it clear which parts of a contract are legally binding. Terms could be written in a contract or similar document, like maybe an example of that would be, that like a contract of employment, where the terms are written in there. So a contract term is, as we mentioned, any provision that forms part of the contract. Each of these terms provides a contractual obligation, which can lead to litigation if breached, as we mentioned. Every contract for a business will have critical terms that fall into various categories. The terms of a contract are there to protect the party's best interests by establishing deadlines, fees, and compensation. Some terms are standard and are used in many different types of contracts, but others can be exclusively specific to the parties involved. So, you could put in a term if you wanted to, to establish certain things. So you may put in express terms, you may put in applied terms, you may put in things that you want to identify. So, contractual language is often used without ensuring party knows the correct legal terms. So typically the contract terms can be defined into three categories. We can have conditions, warranties, or inanimate terms, and these are contracts are universal and need to be are needed for any business and to hire employees, because they'll have contract of employments and they'll have different things within them contracts, so they need to make sure that they've got the terms within them contracts. So contracts, like we said, are legally binding. Express terms have specifically been mentioned and agreed upon by the contracting parties, so that's what express terms are. At the negotiation stage, express terms can either be in writing or agreed upon orally. However, occasionally there will be terms within a contract that have not yet been mentioned by either party involved. This does not mean that they are not enforceable, and the agreement would not make sense without them. And there are implied terms, and these are a set of default rules for contracts on points that are essentially silent. These mandatory rules quietly operate in background and can override the express terms. So the next part of this is we're looking at competition law and why competition law is so important. So UK law is designed to stop anti-competitive behaviour consisting of anti-competitive agreements. Any business whatsoever, whatever its legal status, size and sector, therefore needs to be aware of competition law. Firstly, so that it can meet its obligations, and in doing so, avoid heavy penalties, and also it can assert its own rights and protect its position in the marketplace. Anti-competitive behaviour, which may affect trade within the UK, is prohibited by Chapters 1 and 2 of the Competition Act 1998. Where anti-competitive behaviour may affect trade between EU states, it's also prohibited by Articles 101 and 102 of the Treaty of the Functioning of the European Union, TFEU. The EU rules will cease to have effect within UK from 1st of January 2021, but UK businesses with cross-border activities within the EU will still be subject to EU competition law in respect of those activities, as well as domestic competition law in EU member states. UK and EU competition prohibit two main types of anti-competitive activity, which is anti-competitive agreements and the abuse of dominant market position. So anti-competitive agreements are both UK and EU competitive law prohibit agreements, arrangements, and concerted business practices which appreciably prevent, restrict, or distort competition, or where there is an intended result and which may affect trade within the UK or the EU respectively. And that's within Chapter 1 and 2 of the Competition, Chapter 1 and Article 101. The consequences of infringements of Chapter 1 and 2 can be serious consequences for businesses. For example, firms engaged in activities can face fines, anti-competitive restrictions, firms exposed for damages, individuals in UK can be disqualified. So there's different elements of that can be used. Abuse, the next one, abuse of dominant market position is Chapter 2 and Article 102. Both UK and competition law prohibit So both UK and competition law prohibit businesses with market power from unfairly exploiting their strong market positions, known as abuse of dominance. However, having a dominant position does not itself breach competition law. It's only the abuse of position that is prohibited. EU competition law no longer applies in UK after 31st of December 2020, and the UK Competition Authority and courts will no longer apply it. However, EU competition law enforced before that date, including European courts, historical case law, will continue to apply in UK as retained EU law. This means that UK competition law will continue to be interpreted in accordance with the pre-Brexit EU and case law. However, going forward, some courts will be able to depart from retained EU law in certain circumstances. And looking at the Competition and Markets Authority, CMA is the principal competition law enforcement authority in the UK, though there are a number of sector regulators with concurrent powers to enforce competition law in their respective sectors. These include the FCA for the financial services sector, OTHM for the electricity sector, and Ofwat for the water sector. So now we're going to go on to data protection and why that's so important in regards to businesses or within, sorry, I'll just go back up there. So generally speaking, data protection laws applies to all workplaces, business ventures, societies, clubs, and enterprise of any type. This includes that if you're a sole trader or self-employed, if you work for yourself, if you're an owner or director, it also applies if you only employ a handful of people or even if you employ any people at all. It's so important. There are many benefits to complying with the data protection as well as the law. Good data protection also makes economic sense because it saves time and monies. It also shows that you are, protecting individuals' rights. The Data Protection Act 2018 is the UK's implementation of general data regulation. Everyone responsible for using personal data has to follow strict rules called data protection principles, and they must make sure that information is used fairly and transparently. The GDPR lists the rights of data protection, data subject, meaning the rights of individuals whose personal data is being processed. These strengthened rights give individuals more control over their personal data, including the need for individuals' clear consent to processing of his or her personal data. So it's really important in regards to the data protection laws. There are 7 principles that need to be followed: lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. And these principles are found at the outset of GDPR and inform permeate all other provisions of that legislation. So it's really important, like safeguard information, especially personal data, is really important. So the tort of negligence. What is the tort of negligence in regards to it? Negligence is a tort and actionable in civil courts. Essentially, negligence is typically failing to act with due care, causing harm to someone else. Harm can include personal injury, damage to property, or economic loss. So it's really important that you follow the tort of negligence. It follows that, in regards to really important case in regards to the tort of negligence is the which actually looked at the foundation of the current law, is the case of Donoghue and Stevenson, 1932. It was held that despite no contract, express or implied, an action for negligence could succeed. The claimant successfully argued that there was entitled to a duty of care, even though the deficient goods, which was a bottle of ginger beer with a snail in it, were not by herself, was not bought by herself, but by a friend. So no contract exists between the manufacturer and person suffering the damage. From the case has involved the principle that we each have a duty of care to our neighbour or someone who will reasonably expect to be affected by the acts or omissions. So it's really important when we look at the law of negligence. An example would be doctors, being negligent you know, they need to make sure that, you know, it happens in everyday life. You know, the word negligence conjures up the notion to failure to take proper care. So the law recognises this concept and seeks to provide a remedy to those that have caused injury by a wrongdoer failing to take proper care. So negligence is a large topic, and relates to an act, as we mentioned, or omission which breaches a duty of care. And that's the largest element of it, is duty of care. The next one we're looking at is consumer protection law, and it's there to provide protection for consumers against issues such as like fraud or mis-selling when they purchase a product or service, and consumer markets have to abide by the rules and regulations of these directives. Consumer protection is a selection of laws that protect individual consumers against unfair selling practices. Consumer law is wide-ranging, and consumer lawyers deal with many issues such as advising on consumer credit, which includes drafting credit agreements, acting in court proceedings, and representation at hearings before, for example, the Office of Fair Trading. Trading standards, where lawyers work for individuals, businesses, and enforcement agencies across a full range of trading standards. Issues such as misleading prices, underage sales, and trademark infringement. Prosecutions are made under the acts such as Copyright Designs and Patents Act or the Enterprise Act 2002, and also providing advice concerning consumer contracts. You know, it's really important to identify, you know, that if you are doing anything wrong, that you're able to get the advice. You know, and the Consumer Protection Act 1987 makes provision with respect to the liability of persons for damage caused by defective products. So, you know, you suppliers in the Consumer Protection Act is just required to provide consumers opportunity to examine goods that are delivered. Consumers have the right to return unsafe or defective goods, and they can request a full refund for such goods, provided this is done with a reasonable period of time. The Consumer Protection Act, the next act that came into force was on the 1st of October 2015. The law is now clear and easier to understand, meaning that consumers can buy and businesses can sell to them with confidence. On the rare occasion where problems arise, disputes now can be sorted more quickly and cheaply. So things like alternative dispute resolutions, for example, ombudsman, they offer a quicker element of it. The Consumer Act is there to look at, you know, what should happen if your goods are faulty, what should happen when digital content is faulty, unfair terms of contracts. So, you know, there are many elements that you can use in regards to, you know, and there are advice that you can get on consumer protection as well from advice services. Consumer protection. So it sets out, like you said, a coherent framework of consumer protection, trading standards, organizations. For example, before you making an online purchase of goods in the UK, you must be given all the key information about the transaction and can cancel the contract and return the goods within 14 days, whether or not they are faulty. So they are also protected against a wide range of prohibited, unfair, misleading, and aggressive business practices, many of which are criminal offences in relation to consumer, you know, terms of a contract and things like that. Next element is health and safety. And why is health and safety law so important in regards to, you know, businesses, you know, why is they need to have the health and safety? So the Health and Safety Work Act is the primary piece of legislation, 1974, governing workplace health and safety in the UK. There are also many pieces of regulation which are integral to managing health and safety at work. The implementation of these regulations does not have to be daunting, time-consuming, or costly. So, you know, it's really important that we have the Health and Safety Act in place. It's sometimes referred to, the Health and Safety at Work Act 1974, sometimes referred to as HSW, HSWA, HASAW 1974, or HASAWA. It's an act of Parliament, sets out the framework for managing workplace health and safety. The Act defines the general duties of employers and Section 2, and employees, Section 7(8), to owners, managers and maintainers of work premises for maintaining health and safety within the workplace. The Act itself is primary piece of legislation set out by government. And as we mentioned, there are other sources of acts as well. The Health and Safety Act is the principal piece of legislation for occupational health and safety, as we mentioned, in the UK. The Health and Safety Act, as brief overview, requires the workplace is adequate training of staff. So the Health and Safety Executive is the government agency that deals with advices on legislation and guidance. So the Act requires that the workplace that anyone works in should be adequate training of staff to ensure health and safety procedures are understood and adhered to. So, you know, as a business, you must make sure that you have training in place on health and safety, adequate welfare provisions for staff at work, a safe working environment that is properly maintained, and where operations within it are conducted safely, and also to make sure suitable provisions of relevant information, instruction and supervision. For example, you know, the use of machinery. You know, you should also, if you're looking at working within, you know, you should provide display screen equipment regulations, you know, follow that. PPE is another one that should be followed. An example, you know, management of health and safety regulations. So, you know, and if there's any sort of reporting of injuries, which would be diseases and dangerous occurrences regulations, RIDA. So these are elements, you know, health and safety in the workplace applies to all business sectors. Therefore, the responsibility of the employer to ensure that health and safety is effectively managed within the workplace. However, the approach should be taken to proportion the nature and size of the business, as well as the risk level of the business activity. For a majority of small businesses with a low risk environment, managing health and safety in the workplace should be relatively straightforward. So, you know, make sure that, you know, you are, you know, sending your employers on, you know, training, because that's really important. You know, you should be able to identify that you're sending them on training and you have provided the health and safety training for them, because, you know, it's really important. So there's no cases of, you know, that you've breached any employment health and safety regulations. Project liability. Product liability is the area of law which manufacturers, distributors, suppliers and retailers are held responsible for any injuries to products caused. And any action under the Consumer Protection Act for this or for negligence can be brought for death, personal injury, damage caused to private property as a result of a product defect. Neither type of action can be used to compensate for pure economic or consequential loss. The Consumer Protection Act introduced statutory liability for defective products. Liability under the Consumer Protection Act exists alongside liability and negligence, and in some cases, as a common law claim must succeed where a claim could not be available under the Consumer Protection Act. The Consumer Protection Act applies to both products used by consumers and products used in place of work. The Consumer Protection Act imposes strict liability on manufacturers of defective products for harm caused by these products. And this means that people who are injured by defective products can sue for compensation without having to prove that the manufacturers were negligent. It is merely necessary to prove that the product was defective and that the injury or damage was most likely caused by the product. So, you know, if you're working in a warehouse and, you know, the machinery that's there was defective and you cut your hand or you've got a finger, this would be an element of where, you know, you were injured by defective products and the manufacturers were the ones that were liable for this to produce the product. So these are things, an example of things that may, you know, be bought in where there's been a breach. Duties of employer. So an employer has duties within the workplace, and you know, they have to provide a duty of care, and you know, in a workplace, employers have certain duties to their staff. They are typical legal requirements and relate to fairness in the workplace. limitations on what they can ask of staff and health and safety considerations. So if you, for example, if you work for an employer, understanding their duties can help you better understand your rights. So if employer's duty, regardless of gaining knowledge of this, an employer's duties are various responsibilities to their staff. 7 important duties, firstly, are ensuring health and safety, preparing a clear employment contract, making sure that you've created this contract, that you've provided everything to the employer and it's quite clear. Engaging in fair recruitment, paying minimum wages, providing employee benefits, treating employees fairly, because of, you've got to bear in mind the Equality Act. So, their age, disability, gender reassignment, pregnancy, women, religion, sex, sexual orientation, and giving maternity and paternity leave. So that's really important that you as an employer follow your duties as an employee. And your duties as an employee, in a nutshell, employees are responsible for taking care of their own responsibilities. So, you as an employee need to take reasonable care not to put other people at risk, fellow employees, members. So you have a responsibility as well as your employee. You must take reasonable care of your own health and safety. You have a duty of care as well. You must make sure that you are looking at the notices that are saying, health and safety, you are not putting others in danger, and you are reporting any sort of hazards. You're making sure that you're reporting them, because you have if an employee breaches the duty of trust, you have disciplinary actions. So you as an employee have duties as well. It's not just the employee that has the duties. So the next element is an employment contract. So what is an employment contract? An employment contract is an agreement between an employer and employee that outlines the terms and conditions of their working relationships. These terms include salary, working hours, job description. A contract comes into force as soon as the employee accepts the job. So, as soon as a job offer is put in place, an employee would, accept the job, and then, a contract comes into force as soon as the employee accepts, and the contract will identify, it's a binding document, and it can be agreed verbally. This is when it's agreed through conversations or in writing, for example, a job offer, or through emails. Parts of the employment contract can also be agreed through conduct. This is when a person's actions show there's an agreement, even though they have not written it down or spoken about it. So, it begins when the employer starts. So this is the case even if the employer has failed to give the employee their written statement or not put any parts of the employment contract in writing. So, an employment contract identifies, the employment conditions, terms of a contract, responsibilities, rights, your duties, your working hours, your pay. So employer rights and obligations. So as an employer, you're responsible for making sure your business follows the relevant regulations for your industry. While they may vary depending on the type of job and employment contract in place, the regulations form the basis for fair treatment in the workplace. So it could be things like fair recruitment practices, fair particulars of employment, usually in the form of a contract, health and safety, working time regulations, and holiday, minimum wage. So these are some of the employment rights and regulations. Fair treatment, which prevents claims of discrimination. Your duty to consider requests for flexible working hour, even now when the law changes quite a lot, you need to bear in mind flexible working hours. Your duty to grant maternity leave and pay paternity leave and pay parental leave and allow staff to return to the job, same job. Abiding by express and implied contractual terms. Informing and consulting when changes are made. Informing auto-enrollment into pension and terminating a contract fairly. All of the responsibilities derived from UK employment law, and your failure to meet appropriate standards could result in a grievance. or a claim being made against you or your business. So you need to make sure that you are abiding by the contractual terms and you are abiding by the legal obligations that they are in place. So they've got an agreed salary. You are following the requirements of a minimum legal wage as well. That's one of the things, that you're not treating anyone unfairly, and working hours, pay, discrimination. So these things need to be taken into consideration when you have rights and obligations to an employee. So dismissal is when an employee ends your contract. Okay, so this is when you end the contract. If you're dismissed, your employer must show they've a valid reason for your dismissal. They can't just dismiss you for no reason. And employers tells you are ending the employment with or without notice. Employer constructively dismisses you. Also, they must be consistent, not dismiss you for doing something that let other employers do. If your employer has dismissed you, they must show that they have a valid reason, as we mentioned. There must be a valid reason, and they've acted reasonably in the circumstances. Your employer needs to be have investigated fully before dismissing you. If your employer acted fairly but came to the wrong conclusion, for example, if they have got the facts wrong, this will not necessarily mean that your dismissal is unfair. Your employer must be able to show that they have been consistent and haven't sacked you for doing something that they normally let others do, as we mentioned. You may be able to claim unfair dismissal if you show that you weren't told about relevant company rules, or if there were any sort of policies by your employer that you weren't told about. An unfair dismissal is where the employer sacks you or forces you to leave. An automatic dismissal could be automatically unfair if you've dismissed because you tried to claim one of the statutory employment rights. In most cases, you need at least a year's service before you can make unfair dismissal claims. Managing cases of dismissal. So if your employer dismisses an employee, they should tell you why they've dismissed you. They should tell you the procedure. When the employment contract would end. Dismissing an employee can be very complex. So terms such as unfair dismissal, constructive dismissal, and wrongful termination are often a deterrent from terminating employees' contracts, even though the employee is simply not performing the standards that you require them to do. So as a business, you must follow HR policies in regards to that, and how to manage dismissal cases. Dismissing an employee is always difficult, especially when the employee has been with the company a long time. When an employee has been with your company more than 2 years, there is a significant difference in how to handle the termination due to UK legislation on this matter. So when staff have been employed by your business for more than 2 years, you could be facing serious issues in the event of dismissing an employee without the use of correct processes. So employers need to be careful when handling dismissals in these circumstances, and can be certain they have followed all the correct procedures. As an employer, you should always follow the ACAS code of practice and follow the correct disciplinary and grievance procedures to ensure you do not end up at an employment tribunal for employment unfair dismissal. Employers know their rights. If you as an employee did not follow the correct processes, you are at risk. Tribunal proceedings can be very costly and very frustrating, especially if you could have prevented the hearing from happening with just few simple tasks. As an employee, you should either have a strong HR support in place or be fully aware of the legislation and HR processes. And for a business, it's really important that you are taking on board, what the termination processes, and also when looking at the laws in place when dismissing someone. If an employee has been employed by your business for less than 2 years, it's much easier for the for UK employees to terminate their employment. Employers can only clear unfair dismissal if they have worked for the same employer for 2 years or more. So you've got unfair dismissal, constructive dismissal, and wrongful dismissal, and they can cause serious issues for you as an employee. Because you need to make sure that you are looking at this properly. So all employees can appeal against a dismissal, as we mentioned. If an employee does not follow a fair, reasonable procedure, the employer must may be able to claim unfair dismissal. In order to protect employees across the UK, there are many strict rules and procedures in place that employers must follow before dismissing a member of staff. If an employer fails to correct the steps, the company is at risk of employment tribunal. So you have things like a fair dismissal, which is related to the employee's conduct, capability, or qualifications. Unfair dismissal is a dismissal is unfair in the event of an employee being let go for exercising their rights in regards to maternity leave, or an example, family leave, or anything like that. Constructive dismissal is when the employer resigns themselves. For this constructive dismissal, the employer would resign as a result of hostile working environment created with the aim of forcing the employer's resignation. Got wrongful dismissal. So this is a dismissal in breach of employment contract is a wrongful dismissal or wrongful termination. For wrongful dismissal claims, there's no minimum time of period of service. Employers can take the employer to employment tribunal at any time if the company is guilty of wrongful dismissal. So it's really important, when managing a business, that you have in place HR best practices, and you are able to, identify the best practices and able to identify the laws in place. You need to be consistent. You need to always follow procedures, be fair, make sure you know what the law is, investigate the procedures and look at the disciplinary procedures, and try to avoid any sort of dismissals, and try to have this, protect yourselves by having HR support, but also know the legal requirements when it comes to employment law or dismissals. The next one is managing cases of redundancy. So redundancy is a special form of dismissal. So it's a special form of dismissal, which happens when an employee needs to reduce the size of its workforce. So in the UK, an employee is dismissed for redundancy if the employer has ceased or intends to cease continuing the business, or the requirements for employees to perform work or specific type or to conduct it at the location in which they are employed has ceased or diminished or expected to do so. If there's genuine redundancy, employees must follow correct procedure and make a redundancy and notice period payments. So employers should, if an employer did something wrong during your redundancy process, you may be able to challenge it. So employers need to take reasonable steps to avoid any sort of redundancies. They need to manage redundancies legally and in a way that minimizes the potential adverse impact on both those who lose their jobs and the survivors. And they need to implement a communication strategy to ensure that everyone in the organization has correct information about the redundancy. The next one is managing cases of discrimination. So discrimination means treating people unfairly. So, it depends on in your workplace, you need to make sure that you treat everyone equally. And if there's any forms of discrimination, it's identified. Treating some people differently from others isn't always unlawful. After all, people are paid different wages depending on their status and skills. However, there are certain reasons for which employers can discriminate against by law. If a worker says that another worker employed by you or your agent have unlawfully discriminated against them in a work situation, your responsibility is to deal with the complaint in a way that finds if there has been lawful discrimination and that is put in the situation. A worker may complain to you and make a claim in the employment tribunal, and there are alternatives since the person complained still has the right to make claim under the employment tribunal, even if the first complained to you. Managing cases of health and safety, and that's really important when it comes to health and safety, because you need to look at the risks. You need to make sure that you have put the right training in place. Health and safety management is an ongoing process, not a one-off task. It is not enough to just control the risks in your business. So you should make sure that they stay controlled. Under the management of health and safety at work, every employer must have arrangements for effective planning, organisation control, monitoring and review to protect individuals. By following the plan to do, check, act approach, you can plan what you need to do. You can do the right things to implement your plan. Check your control measures. Act if your measures are not working. This will help you find out where you need to make improvements. So as an organisation or business, this is one of the elements that needs to be covered quite a lot, because you need to make sure that you need to prepare health and safety policies. Make sure that you manage risk, and also risk assessments, report accidents. If there's any accidents, consult your workers, provide training, first aid at work, and display posters everywhere. You should make sure you're able to manage risk in order. So get management, plan the safety management system, make sure there's plans in place so that there's no risks or anything. Make sure the workers are safe. There's posters displayed, everything. Examples of formal management systems can be, to help you manage health and safety, is to make sure, you've got, if there's any sort of elements of diseases or any sort of resources you're using, that any sorts of things like, if you need hard hats or you need PPE, keep the protective equipment available, keep up to date with your procedures and the protocols, and maintain, guidance for new employees as well, and maintains that the laws are changing and the policies are up to date. So we've looked at the elements of a contract. We've looked at the terms of health and safety issues. These are some of the resources we've used for Learning Outcome 2, and in regards to, the links are there. You can go onto the links and they will take you to the actual resources we've used for this session. If you have any questions or any queries around Learning Outcome 2 or around the business law module, just email learnerwork@ukvarsity.co.uk. Submission of the assignment will be done at learnerwork@ukvarsity.co.uk, and that is normally done after we've completed the unit. So we've done Learning Outcome 1, and this is Learning Outcome 2. The next learning outcome we'll be doing is Learning Outcome 3, and so on. And then we do an assignment discussion, which will help you and support you around what is expected of you to do in the assignment. And then you will do your assignment. So if you don't have any questions, and thank you for attending the session today, and I will see you in this next session, which is Learning Outcome 3. Thank you.